Thank you, Scott. Obviously, Scott's introduced me. I'm Shane McDowell, come up from Brisbane. Happy to be here today to participate. As you know, we're all external students. It's a really good opportunity to meet other students and the staff here face to face. So to discuss, our dissertations and our studies. So thanks everyone for being here. Just a quick background about myself. I started law a few years ago. I had a roster that allowed me to pick. It's something I found interesting since being a little boy. I used to go to my grandparents' house, and after school we used to watch Judge Judy together. That was so I'm obviously familiar after all of two minutes of law that that's not real law, but at the time that was something. It was in a courtroom, so it was law to me. But yeah, I pursued law because it was something interesting. I found it really exciting, so I undertook that. I graduated last year. Thinking uni was all was 8.5 months pregnant, and she was equally as excited as I was finishing. Yet here we are again for another year. Now, since I graduated, I've been working as a clerk in a firm predominantly criminal and family. We're just discussing family law and joys of family law. But I've always been interested in criminal law, so that's why I undertook this honours. This is pretty much what I'm looking at for my dissertations to expand my knowledge on some of those concepts that I've looked at in undergraduate studies. Actually, getting into honours was itself took a lot of negotiation and advocacy skills to convince my wife to let me do it. So, so that in itself was an experience. But essentially, I had two main goals. So that was going to help me professionally, something that could help me learn and was relevant to the work I was doing. And secondly, I also wanted to do a dissertation on subjects that's topical, that's relevant in today. And it's something I found very interesting because I think that would make my studies a lot easier. A couple of years ago, I can't remember exactly where, but I read this article in America about a terrorist threat that sovereign citizens are the greatest domestic terrorist in America. And I remember reading, some of these articles about what they believe and what they studied, and the arguments they took to court for any number of simple matters. I found it just really, really interesting. So that's what I wanted to have a look at, is why do people represent themselves in court? Was it to do with that, or is that just an example of one of the products of representation, that it's a small group? But when I first began my dissertation, we just seen Brexit. We were just talking about we had Donald Trump got elected. We've seen Pauline Hanson come back again, and we've got just this time now where populist leaders are coming back into vogue, so to speak. So I wanted to have a look at that and see if there's any correlation between populist political movements and populist legal movement, as in, was there any kind of correlation there? Now, what I actually did, I remember I was talking to some colleagues at work about lenient judicial sentences, as in the judges were out of touch, as in what the public perception of judicial sentences were. And one of my colleagues, he actually mentioned about there was a study that was done for sentencing guidelines. So you'd have lay people come in and they were giving sentencing guidelines and ask them to give their sentence. And what they actually found was that what lay people were finding for what was an appropriate sentence was actually a lot closer to what the actual judicial sentence was than what they'd first thought. And the argument that the study had was basically they were saying, once we engage people in the legal process, they're not just more inclined to understand it, they're more willing to do further research and want to understand it. So that's what I wanted to look. I want to see, is there reasons why people are representing themselves, particularly in criminal matters where there's very real risk of pecuniary, non-pecuniary penalties. I want to see, is this a conscious decision people make? Is it to do with distrust of lawyers, distrust of professionals? Do they feel they can just do a better job? Or is this one that obviously always comes up for lawyers? So that's what was essentially the central theme of my first dissertation. Just discussing a little bit more. So as I mentioned, we're talking the last 15 years where populism is really becoming quite apparent. It's a global movement. What's actually quite interesting about populism in politics is populism is in itself an isolationist policy for each country, but it's actually a global phenomenon. Global issue where you have, for example, Europe and North America tends to be conservative or far right populist rhetoric, whereas you have like Latin America, where it's actually the far left populist rhetoric. So very different political spectrums, but they all, the whole purpose is the forgotten class, the people who got left behind, who they want to empower those people. So if we have a look at the forgotten class, it's normally the middle class who feel like they've been left behind. If we consider in a criminal trial or criminal hearings or anything criminal in that respect, the forgotten class of people who feel disenfranchised with the political process, without having access to legal aid, there's a real risk that people are becoming invigorated as well in that they're left behind where they don't qualify for legal aid, but they're not quite financially capable to actually afford representation themselves. So this has a number of issues to it as to whether what they want to do. Do they want to represent themselves? Do they want to take a loan out? That kind of thing, or what their processes are, and also what actually happens with the court when if they decide to represent themselves. Whether it's not just cost and efficiency to the court, but it's also issues to the person who represents themselves. For what actually happens to them, the social cost, and the fact they lose a lot of chance of mitigating their pleas without it, without proper representation. Now, there's a lot of research that's been done about access to justice and how do we get more people with representation. The big issue is cost, of course. That's what's holding up access to justice in that regard. So about 20 years ago, the federal government started to reduce funding for legal aid, and pretty much every study now, not every study, but pretty much all of them are saying we need to request more funding. That needs to be what happens. I actually personally believe in that as from my own personal view. I think that's absolutely necessary, but unfortunately it's not politically popular to give more money, particularly now because we see the distrust of the professions, meaning it's really difficult to engage the people that are becoming more vocal. We need to engage them in any kind of rectification. So the current approach from the legal profession is populist rhetoric is short, sharp, it's inflammatory. It's not really what you'd call legal. It doesn't have a lot of support from the legal fraternity because it's pretty much opposite to what we actually are looking at doing. But as I said, it's a very interesting period we're in at the moment where these movements are here. They ebb and flow over time. So we've had history, like Julius Caesar was one I mentioned in my dissertation. I mean, he's very popular, or that we know of, who instituted populist policies. But it ebb and flows. Whether or not the role the internet has in making this possibly a more lasting phenomenon is probably requires a lot more research, and it's certainly not. It wasn't covered in as greater depths as probably needed to be in my dissertation. But the authority of Diedrich and the Queen is basically, the authority. There's a number of issues that we've discussed in that, but one of them is that there's no right to publicly funded counsel in all matters. So what the courts look at with underrepresented parties is they balance the right of the unrepresented person to have their case heard with the right for the courts to run efficiently and expeditiously. Now, what they do in that regard is the general rule is in the interest of fairness. they'll take cost efficiencies away, as in cost efficiencies are less relevant than access or the right to be heard. So what I looked at in my dissertation was specifically about costs, in that they do remain the driving factor of why people don't get representation, but there's definitely more than that at the moment. But that's the predominant reason at the moment. Now, what I looked at was the decision of Latutis and Casey, which was a decision that went all the way to the High Court about costs for summary matters. So when you successfully challenge a summary matter, that you get costs awarded, the decision was that in the interest of fairness and justice, you should be primarily focusing on the accused. So what happens with an accused who, for whatever reason, has found themselves in a situation and has successfully challenged that? Latutis and Casey said that ordinarily costs should be awarded for those parties. Now, they did do some limitations to that. Now, pretty much as soon as that came out, Queensland introduced Section 158A of the Justices Act, which immediately curtailed that, the avenues for costs. So what I had a look at in my dissertation was considering whether or not that was really the right approach, because quantifying justice as a dollar value isn't really justice in any real sense of the word for me. Okay, so that was the outline of my first dissertation. It was very difficult. Obviously, it's the first dissertation to do. But I was happy with it. I went through and got a lot of feedback, and I've made a lot of amendments to it, and it's still in, I'd say, still in production. But the major difficulty I had with that is because unrepresented and self-represented people, they don't belong to one group. I mentioned at the beginning about sovereign citizens and things like that, but there's not one specific group, there's not one specific belief. So it was very hard to get specific evidence on matters. It was a lot of anecdotal evidence, a lot of extracurrial articles from judges who witnessed matters and things like that. But there was, of course, a lot of case law as well with like, for example, there was one matter where a lady, I think she was trying to get out of a speeding ticket, carried in the Magna Carta with her to prove pretty much every single law since the Magna Carta was wrong. It was, and these, mind you, these cases aren't just one-page decisions. They do entertain these arguments for quite in depth. So the second dissertation, what I'm doing at the moment is essentially, we're talking about rules of evidence, complex rules of evidence, being specifically designed to protect defendants. Now, if you are unrepresented, these safeguards, these complexities, what relevance are those complexities to an unrepresented party who's obviously going to struggle to understand them? So they're designed to prevent the instrumentalities of the state, I think is the exact quote of the High Court. But when you're unrepresented, the fact that these are complex rules are probably not going to assist you that greatly, because you're not going to understand them in the limited time that you have the limited time you have at trial, and the limited assistance that the courts can give you. Okay, so that's in a nutshell. That's what I'm looking at: is, are the rules in my second dissertation, are the rules of evidence too complex to understand for an unrepresented party in the confines of a trial? So I've done some primary research, speaking with some practitioners and barristers, just to get their experiences with procedural law, evidence law, and any observations they've had either against unrepresented parties or what they've seen in court about it. So what I'm looking at there is like common themes. Is there common set themes? So it's a short study of six 6 practitioners, but there has been a lot of common ground, specifically about evidence law. I think Brown and Dunn, I had 6 interviews. Everyone said Brown and Dunn was one that's constantly coming up for anyone who's underrepresented. It's very difficult for them to understand, particularly around tactics. They consider it to be tactical to not put these issues to someone who's being cross-examined. That's pretty much my 2 dissertations. Before I open up for questions, thanks everyone for listening. Like I said, I hope I didn't waffle too much. It is for me, a very interesting topic, and it's very difficult sometimes to narrow it down in one area. So thanks everyone for listening.
Thanks, Shane. Questions? I'm sure you do.
That's one thing. I think you need to be really careful about how long of a bow you draw between populism and self-refuge and populism and other things. I'm not convinced personally that there is a substantial wave of populism occurring. I think that what there is a substantial wave of popular discontent with traditional institutions. And that one of the ways that is playing out is that people are focusing on a personality as opposed to focusing on institutions such as parties or parliaments or courts or whatever. And that the underlying problem, I mean, it's not a populism that comes because you've got these remarkably charismatic people who are coming along and saying, hey, vote for me. It's populism that's coming along this way because people are saying, well, we don't like the current institutional environment and we'll do something else. And then the dominant personality becomes the default option. Mm-hmm. So there's a question about whether people are running towards populism or whether they're just running away from traditional institutional structures. But that's just a comment, and you may disagree with it. It's not something I'm going to press. What I would press on you, though, is in terms of your second dissertation, 2 things. One is I think you're going to have to draw a very firm distinction between self-represented litigants in places like the Magistrates Court versus self-represented litigants in the higher courts.
Yeah, absolutely. That has been, I haven't clarified it in there, but a big issue, and it was definitely brought up in the research that I've done. There's a major difference between the lower courts and the higher courts. The higher courts are different types of unrepresented party defendant. A number of participants said that the actual, if they're in the high courts, because of Diedrich, if they're in the high courts and they're underrepresented, it's normally a choice for the council for whatever reason.
But also in the Mags Court, most reasonably intelligent people who've had a visit with the duty lawyer that morning, and particularly those who are intending to plead guilty, are going to be fine without representation, because the magistrates don't usually worry that much about the law anyway. What they want to do is to make common sense decisions that result in a non-appellable outcome. Yeah. Okay, you're already across that distinction.
And the issue in the lower courts as well, which was brought up time and again, was most of the issues in the lower courts are fact-based questions.
That's what I mean when I say the magistrates aren't that worried about the law, because usually the law is not the context, the facts of the context.
That's right. Yeah.
My impression from my experience as counsel is that in terms of rules of evidence, it's often the easy rules rather than the complex rules that trip up the self-reps. I'll explain what I mean. Mm-hmm. If I'm calling evidence and there's another barrister at the bar table, I'm not going to try and lead, because if I lead, the barrister's going to object. If I've got a self-rep down the bar table, I can push that a lot further in terms of the sorts of questions I can lead, in terms of whether I can lead stuff that might be hearsay, because I'm not going to have to make a Subramanian argument against the self-rep. They don't know what's going on. And so it's not that you're pulling some complicated rule of evidence, like say similar fact evidence or something like that. It's just the fact that you know that you're a lot less likely to get objected to. And so you can push the line a lot further on the simple stuff. Yeah,
with the researcher, so what to do with the evidence? I'd say, are they too complex? The underlying, the majority of the feedback that I've got from the research, pretty much, it's not so much themselves, but the procedures, the tactics. So a lot of the time they find it difficult if the judge says you may want to object to that. They consider that as being an instruction to you should object. There was a lot of difficulty with tactics. Otherwise, it's admissible, admitted and not object. Where they have the judge doesn't know, what the unrepresented party is thinking as an tactic, so it's very difficult to comment.
Yeah, Brown and Dunn. I think Brown and Dunn is going to trip up virtually any sort of fruit.
Yeah, and that was like I said, tactically they just don't understand. They want to bring that in as in I've got them later on and bring it back, and they're not allowed to. And there is some case law as well from magistrates, appeals from magistrates courts, where the magistrates themselves have given the wrong advice and have successfully appealed those decisions. So the main issue, and you mentioned it's simpler issues, they came up, of course, hearsay. They said that people come up all the time with stat decks and say, oh, here's a stat deck of a witness saying they saw this.
But I don't care about that. So if it does that, I'm just not there. And all of a sudden they'll have no evidence to roll over that party, and that's cool.
Mm-hmm.
It's more with the self-reflective capacity to defend themselves against me. If I start leading, because I'm not going to lead too far, because then the bench will have a go at me, but you can just press the line a little further against the self-rep than you would against another practitioner.
Yeah, and something I should point out as well, I did do a discussion in this dissertation about the separation between legal capacity and legal ability, and the threshold for legal capacity. The courts are very, very reluctant to take legal capacity from someone. That's actually how I start I didn't bring that there, but that's the first section of my dissertation there, and settling that is because, like I said, the court's extremely reluctant to take away the right to appear.
Other questions?
Yeah, I've got a quick one. Just happened I received a report this morning that emailed something called geochronicity. Have you heard of that? Geochronicity talks about cycles in geopolitics, and sort of like biorhythms, and when certain cycles coincide, there's wars and that sort of thing. But I can email it to you.
Yeah, absolutely.
But the proponents have never gained much traction, but it's interesting.
Yeah, as I said, the first topic I did, that was, like I said, very interesting to me. And as Anthony mentioned, it was difficult to draw a concrete link there. It was very difficult. That's why I wanted to do some primary research, because a lot of the information is anecdotal. So that was a difficulty for sure.
Yep. You give me your email address later and we'll zip it over.
Sure.
And it does reinforce what we were saying recently about ethnography and the lack of ethnographic research in law, because there's what people do, there's people what people say they do, and a lot of the formal stats and the formal things talk more about the high level arguments around self-representation and don't actually engage with what actually happens. And certainly you're not going to be likely to be in a situation where someone is going to say that, undue duress is put on a self-represented person, such as when I do this and when I do that, in a formal report, whereas in an anonymous ethnography they may be more forthcoming. And I think one of the best parts from what I saw of your draft was it was a report somewhere on the problems of self-representation and the way in which it made the law impenetrable to average people, but it was written in so many $10 words that it made its own argument. That you used such complex language to explain why it was a problem. That
one final thing that you may already be across, but in terms of self-represented hierarchies, an overwhelming number of them are prisoners. I wasn't, particularly in the Court of Appeal. Mm-hmm. Almost every application stage in the Court of Appeal, you will see a prisoner who's making their application from the visual room in prison. There's usually have laptops that the prisoners can get access to, only if what they're doing is making an appeal. And so they're appealing their conviction, or they're appealing
It's
their
in
sentence,
sentencing, yeah.
or they're appealing parole board decisions not to grant parole.
Mm-hmm.
And the prisoner's legal service is very limited in the support they can give. And you can see that you've got three members of the Court of Appeal and a room full of barristers who are waiting their turn, and you've got someone dressed in an orange jumpsuit sitting in an audio-visual room somewhere trying to make an argument about some viewpoint that they don't understand. And so that's a specific population that you might want to be aware of.
Yeah, I haven't considered that. I have been in court before with prisoners who come in and basically I've found that you don't have for bail, they might appear there and say, look, my bail was rejected, I want to apply again. And he said, well, what have you done since? And the prisoner will say to the magistrate, just tell me what you want me to do and I'll make sure I've done that. And he said, I don't give you advice about that, you tell me what you've done.
Well, if you're in Brisbane, if you go along and sit in the Court of Appeal, or even just in the Supreme Court on most application days, criminal application days, you'll see that quite often there's 2 or 3 prisoners coming in on AV, and one of them being Waco, one of them being Capricorn, and one of them being in Maryborough.
Yeah.
And they take up, each of the self-reps takes up as much time as 5 or 6 represented cases.
Okay, well, that's come to the end of our question time. Thank you, Shane. Thank you, everyone, for your contributions.